Giorgio. So, Excellencies, ladies and gentlemen, dear colleagues, dear students, on behalf of the Centre d'études juridiques européennes of the University of Geneva and on behalf of the organizers, it is my pleasure to welcome Professor Giorgio Sacerdoti for this conference on dispute settlement in the WTO and in the free trade agreements concluded by the European Union with its partners. It is worth noting the great interest in these issues nowadays. There are more than 100 participants to this webinar coming from academia, from practice, from diplomacy, from governmental as well as non-governmental agencies. So a very diverse audience we have today, Giorgio. A couple of words just to introduce the topic and to introduce yourself. When disputes arise in international trade, they can be settled with binding rulings under international trade or investment agreement. For the WTO agreement, which is part of your topic of today, for WTO agreements, members can launch such disputes through the two-step WTO dispute settlement mechanism. This is the multilateral dispute settlement provided for in that international organization. However, since the blockage of the WTO appellate body by the US, the highest instance of the WTO is plunged into crisis, and we will listen to you on that topic. The European Union and a number of trade partners set up the MPIA. The MPIA is a temporary solution that have been agreed upon by a certain number of parties. However, these same parties continue to seek a solution to the appellate body crisis. As long as the blockade continues, they will be using the MPIA. The European Commission recently recalled its commitment, or the European Union commitments to the WTO reform. This has been recalled in the trade policy review in last February 2021. I must say that at the same time, along these WTO dispute settlement mechanism, the European Union in its bilateral trade and investment agreement provided for state-to-state dispute settlement to ensure that the rights and the obligations that are provided for in these FTAs are respected. And it is specifically designed to deal with disputes arising out of the rules of the bilateral trade agreement. We do have two very good examples thereof. The first one I would like to mention is the report of the arbitration panel on the Ukraine wood export ban that has been rendered in December 2020, implying the application of the association agreement between the European Union and Ukraine, as well as the GATT provisions, notably Article 11 of the GATT, as well as, of course, Article 20, letter B and letter G of the GATT, as justification to potential violations. Another recent example of this, I would say, bilateral way of resolving disputes is the European Union Korea report. But this is not an arbitration report. This is a report of a panel of experts that has been rendered in January 2021. And there it was about the respect by Korea of its labor international commitments. Probably we will discuss these as well. So we can observe a recent trend and new developments in these bilateral dispute settlement that have been provided for by the European Union in its international organization. But as we know, there is, of course, the multilateral WTO system, which is still there and for which many international actors are working on in order to deblock the situation. So to discuss these issues, I am very happy to welcome Professor Giorgio Sacerdoti. As many of you know already, he is a professor at the Bocconi University. He was a chairman of the WTO appellate body. He exercised many functions at international level at the OECD and in other places. And more recently, he was a member of the arbitration panel in the Ukraine wood export ban. So, dear Giorgio, you are one of the best persons to discuss all these issues with us today. And without a delay, I pleased to give you the floor.
Thank you very much, Christine. It's a pleasure of being back to the University of Geneva, virtually, where I lectured in your programs several years ago. And now we are prevented. This is one of the issues of, on one hand, we have wider participation through Zoom and other platforms. On the other hand, we lack the pleasure of discussing in person. So I welcome your invitation, and we agreed on this title. This was also based on my recent experience you mentioned as a EU appointed member of the EU-Ukraine panel. Of course, I will not comment on the sequence of the deliberate and on some other aspects, no comment the panel, because my former friend, my friend and former colleague, Georges Bissab, who was with me at the appellate body, used to say, we have the power to decide, but we have to refrain from the power and the pleasure of academics to comment. But of course, here, this is a broader, now, nice, but how do I go on with my slides? Excuse me, because I changed the, can you remember me how I, oh, just probably, well, apparently it's blocked. Excuse.
Yeah.
Here. Wait. I don't know how maybe I should have gone to the other format. This format, excuse me, can you see it?
No, we only see you for the time being.
Ah, you don't see my slides. Wow, that's bad. Excuse me.
You just have to go again.
Yeah. I have these on the side, so I can go on through better.
Okay.
So I have here a general presentation, trade disputes at the WTO and in bilateral regional trade agreements, comparing some points. Of course, there is not only the EU, also the NAFTA and the new US CM agreement. The new NAFTA has also provision on trade disputes, so have some others. The WTO, you explained it at the beginning, you recalled, it's for disputes concerning any WTO agreement. It has a 2-level, although the appellate body now is hopefully temporarily paralyzed. There are bilateral disputes, but you have third parties participation. Any member of the WTO can participate and so give useful inputs. This is, of course, not provided in bilateral agreements. The reports, not the report to be adopted, must be adopted by the DSB to become binding. And then there is a multilateral surveillance of compliance. And if not, there is a suspension of trade benefits of trade concession, what we call countermeasure of sanction. It has been massively used, as we know. It's rather lengthy, more than had been provided in the agreement. And there is a support of the WTO Secretariat that helps, of course, maintaining consistency or organizing the matter. Now, the EU Free Trade Agreement, it's a novel experience because, as you see here, my last point, hardly used until recently, and the disputes with Ukraine and with Korea, which are quite different, as you mentioned, also in the format, are the first two experience brought to the end of a procedure with a report of a panel issue. Now, the panel system, the trade system in EU Free Trade Agreement is closely modeled on the WTO. It's bilateral. The panelists are not chosen by the party ad hoc like in Geneva or by the Director General, but the agreements have annexed at the next a list of one party, 4 members of the other party, and 4, let's say, neutral. There is provision for amicus curiae, which was a contested issue in Geneva. And the report, I speak about the trade panel reports, are binding. There is no appeal. There is no secretariat. Often when we look at treaties, at agreements, some practical issue which seems very minor, quite important. In this first EU-Ukraine, there is no secretariat who makes the practical works, who sends an email, who drafts personally. So that was an issue, although the parties agreed that the panelists themselves could choose 1 or 2 assistants, and we chose an Ukrainian assistant, and since the chairman was Professor Christian Hebel of Bern, we chose Professor Ilaria Espa of Lugano, who has written on export restrictions, and so de facto we had a base in Lugano. And then the report is binding. There is no adoption by the parties or so. However, there are not just trade chapters with trade disputes in these agreements. There are also chapters on trade and sustainable development, both in Ukraine and in Korea agreements. I have not looked in details, they look quite similar. So environment, labor standards, and similar. And in that case, there are panel of experts who work like panelists in trade, but whose report are sent to the parties for their attention, but there is no binding character nor a compliance mechanism. Now let's see shortly to give an idea of the content, because they are rather lengthy. Each of these reports are about 100 pages of text. These disputes concerned started under the association agreement, so it's not a free trade agreement, but it's in substance, it's a kind of free trade agreement aiming, at approaching the Ukraine economy to the EU single market. The name is Restrictions Applied by Ukraine on Export of Certain Woods Products to the EU, based on Chapter 14 on dispute settlement of the agreement. Now, the timing is interesting also because time, if not of essence, is of some importance. And as I mentioned, the WTO has become rather slow. Here it was rather quick because consultations was requested in January 2019. There was then a meeting in Kiev that didn't lead to results. Then the EU requested the panel on establishment. This is typical in a trade matter. It's the Title 4, Trade and Trade-Related Measures, Chapter 1, National Treatment, and then you have the procedural provisions in the agreement, Chapter 14 on dispute settlement. It's the same number than in the Korea agreement, and Annex 14 on rules of procedure. That was asked in June 2019. Here, of course, the parties have agreed on the composition. They have to pick from this list names. This was done on August 19. Then there was a period to discuss this functioning of the panel, like, for instance, the assistants, the secretariat, the language, which was decided, agreed to be English. And so there was a first meeting, procedural meeting in Brussels in 28 January, where the working rules were established. You find them in the annex of the report, which is public on the website of the Commission of Ukraine. And so how many briefs, announcement for Amici Courier, and so on. Then, however, immediately afterwards, you know, this was 28 January, already at the end of February, beginning of March, everything was disrupted. The hearing was supposed to take, that's written also in the report, to take place in Kiev in end of March. It couldn't take place, and it was hoped it could take place in June. Well, finally, because the agreement provides for a 90 or maximum 120 days for the panel to render its report. But this was not possible, but the delay was not so much. Virtual hearing in September. There is an interim and a final report like at the WTO, which, not having an appeal, may be especially useful as it was in the original GATT, because this allows the party to have a additional, let's say, dialogue with the panel on certain issues, on certain points. And then the final report was issued last December. There was no Amici Courier filed, although they had been announced, but then they weren't really filed. And there is publicity, though you can find the briefs of the parties, the working rules, and the report in the websites of the parties. Now, what were the claim and the defenses? The claim of the EU was closely based on a breach of a provision of the agreement, which is, let's say, basically identical to Article 11 of the GATT. So this dispute was almost like a GATT dispute. The EU challenged two measures by Ukraine, two export prohibition, one dating back to 2005, to certain wood species that Ukraine defines as rare and valuable, and which are basically in a international catalog of endangered species, although the parties discussed about whether those species in Ukraine were really in danger. And this is mostly, let's say, commercially relevant. Cherry, chestnut, acacias, so species which usually are not traded at all or not truly in big quantities, and no statistic were provided. The really important thing is Ukraine temporary provision, but it lasts 10 years, of unprocessed timber export. That is, all wood from Australia, unprocessed, cannot be exported, neither to the EU nor to other countries. And the big part, of course, is pine trees, the big pines, and they come from the forest of Ukraine in Carpathian area neighboring Romania and Slovakia. The provision allegedly breached was Article 35 of the agreement that prohibits import and export restrictions by the parties and explicitly incorporates in the agreement Article 11.1 of GATT, or the whole of Article 11. What were the defenses of Ukraine? Well, there was a jurisdictional defense, and you'll see also Korea raise a jurisdictional defense. The Ukraine said the dispute, well, it's not really a trade dispute. Our measures are for environmental purpose, and therefore Chapter 13, Trade and Sustainable Development, applies, the same in case of Korea. So Ukraine submitted that a group of experts, it's called here, whereas in the agreement of Korea it's called panel of experts, should have been convened and would have been competent. Then there was a defense saying this Article 35 would not be enforced during the initial 10 years transitional period. In the merit, Ukraine raised the defenses of Article 20B of GATT, and Article 20 and 21, the GATT defenses are made explicitly applicable by Article 36 of the association agreement, immediately following 35. So the Ukraine raised letter B, measures necessary to protect plants' life and health for the 2005 ban, and Article 20G for the 2015 ban, the protection of exhaustible resources, measure to ensure the conservation of exhaustible resources in connection with domestic restriction to the same effect. What were the panel finding and ruling? Well, on jurisdiction, the panel confirmed the claim of the EU that the dispute was brought as a trade dispute for a trade restriction under the agreement in GATT, and therefore the panel was competent. Of course, those interested in international law, you can read a little bit on this. The methodology followed. There was an interesting aspect that this defense and the one of the transitional period was raised late in the proceedings by Ukraine. So there was a defense also by the Union that jurisdictional objections have to be raised as soon as possible, and they were late. The panel considered that this was found well grounded, but went into the merits anyhow and found that the demand was on a trade matter and on the trade chapter, and therefore it had jurisdiction. Now, the decision on the two bans went in different direction. Let's say Ukraine won on the 2005 ban and the EU won on the 2015 ban. On the first ban of the 10 species, the panel considered that there were indeed species that were in various international catalogs. There was a special legislation in Ukraine, at least for some of these species. And so it was considered that although it was an export ban on the face incompatible with not Article 9, except, excuse me, by Article 11, I see a mistake, it was justified under 20B, and it was not applicable discriminatorily under the chapeau, although you can read there that the panel had some doubt that really the domestic legislation in Ukraine was clearly preventing the trade of these products. The other ban instead, it was found that it fell under 20G, so the panel did not even need to go to the chapeau of Article 20, whether it was applied discriminatorily. Because first, it was not evident or shown that such a massive, complete ban was relating to the conservation of exhaustible resource. The panel got evidence, for instance, that when this ban was passed through the parliament of Ukraine, it was several times stated that it was meant to develop the domestic wood, furniture, and so transformation industry, so that it had a protectionist purpose. And there was also evidence that the forests in Ukraine are not really endangered, that they may have even raised the quantity of plants and forests, and that the problem may be rather of illegal logging, of corruption, which the blocking per se would not fully resolve. And then especially the question of made effective in conjunction with domestic restrictions, because Ukraine had no domestic restrictions in 2015 when the ban was introduced. Then a provision on restricting was introduced by a new statute in 2015, but the cap on domestic production was set higher than historically the domestic consumption. So it didn't operate really as a restriction. So that is what was found. It's still interesting here, you have a specific aspect concerning the chapter 13 on trade and sustainable development, which is rather broad in the agreement between EU and Ukraine, because although it was not found relevant neither on jurisdiction nor on the 2015 ban, still the panel in various sentences did mention the importance that the parties have attributed to this aspect, and this can also be taken into account when dealing with trade disputes. And Ukraine asked that if Ukraine would lose, let's say, the panel should give a recommendation on how Ukraine should implement. Now, the panel refrained from this because there is no provision in the agreement that empowers a panel to do so, whereas in the WTO Article 19 of the DSU authorizes panels to make suggestions if the parties ask, although usually suggestions are not made. So at the end, there was a kind of recommendation, first of all, restating what is the legal effect of these findings and ruling, that is, that the party that is found in breach has to take any measure necessary to comply in good faith with the ruling. But mentioning also, the panel also mentioned taking into account all relevant provisions of the agreement, including those of Chapter 13, and specifically a provision that is there on trade in forest products that have we encourage the trade in sustainable forest products. So, okay, let's go to the other panel. Now, of course, you understand I'm more familiar with the panel of Ukraine and less familiar with the decision on the dispute between EU and Korea, although I have been studied, and since there, the EU member was Professor Laurence Boisson de Chazourne, whom you well know in Geneva, not only in Geneva, and she may be listening to this webinar. So please take my observation with some reservation, as the case may be. So here too, the proceedings are rather short. You can see here, because the two proceedings were about the same time. There were also these proceedings disrupted by COVID and were made online. Moreover, the president of the panel died at a certain point, and Australian had to be replaced. There were here briefs by trade unions, Amicus Curiae, Amici Curiae brief. And the report does not follow, of course, the WTO model, because there is no WTO model for these provisions on sustainable development and dispute settlement under that in the WTO agreement. And it's more a traditional international judgment. At the beginning, there is an extensive section on that the Vienna Convention provisions are the guideline or the applicable rules for interpretation of the agreement. Now, this panel of expert report, well, what is their nature? And it would be the same under the Ukraine agreement or others. Now, there is a trade and sustainable development chapter. It's very much hortatory and aspirational traditionally, to encourage the parties to take into account within the trade, the non-trade aspects, the protection of the environment, the non-lowering of the level of protection in labor, also in environment, maybe something on competition. And if the parties have a dispute, they can appoint a panel of expert report. And here you see what the agreement says on the effect of this report. The report is not binding per se, but there is a good faith, best effort provision for the implementation of the panel. Here they are called findings, whereas in the trade chapter they are called both finding and ruling. So the final is the ruling. Now, what were here the claim and defenses? It concerned labor law in Korea and the fact that Korea is not, in general, let's say, it's not doing what it is supposed under the treaty to fully respect the ILO core standard convention in certain respect. And there were really two claims. First, the EU challenged certain provisions, 4 sets of provisions of the Trade Union and Labor Relations Act of Korea as inconsistent with the provision that the parties commit to respect, promote and realize in their laws and practice the principle concerning the fundamental rights of the certain ILO convention, which are listed there. And here there were conventions 87, 98. And the second one, which is maybe even more relevant, that Korea had taken an obligation, both parties, to make continued and sustained effort toward ratifying the fundamental ILO convention. The EU countries have ratified. Korea still has not ratified certain core convention, which is rather surprising, I would say, from a country which is so not industrially developed and active in international trade. And I want to point out immediately that a very similar provision has been inserted in the recent investment treaty between the EU and China, which you know is subject to discussion and polemics. So this case can shed light on what may be really the substantive effect of such a provision, since also China has not ratified certain conventions, notably the labor, the compulsory labor convention. I'm not sure that's the name, and you know this has to do with
forced labor.
Forced labor, yeah.
Forced labor.
What were the defenses of Korea? Now here, Korea raised defense, saying, first a jurisdictional defense, saying, well, these aspects of labor, which especially in the first claim EU was raising, are not related to trade between the parties. They're just domestic legislation. There is no obligation of harmonization, and therefore they were not justiciable under the agreement. And here I think there is a very interesting discussion, and also length in the panel report, on what is meant trade-related labor commitments. It's not strictly in export trade, but it's there is reference to the preamble, declaration of ILO, declaration of the UN, sustainable development, the importance of the labor conditions. And Korea referred specifically to a panel report in a bilateral agreement, free trade between the US, Dominican Republic, and CAFTA countries concerning the labor conditions in Venezuela, where, in Guatemala, where the US claimed that Guatemala was not enforcing effectively its own labor laws. And there the panel rejected the claim of the US, using an argument saying, well, similar to the one Korea raised, that is not the agreement concerns labor laws and standards relating to the commerce between the two parties, and not just in general. And this was rejected here. And the panel also looked at the different texts of the two agreements. So this could be also a caution against expanding too much reference to experience and other agreement that may be like, but not exactly. As to claim one, which was, there were 4 provisions challenged, the Korea said they were actively engaged in applying those provisions. As to claim 2, the Korean government has announced that it would submit bills for the ratification of this convention and has submitted bills, you see, very late in October 2019. So when the dispute had already started. What did the panel find? It rejected the jurisdictional objection because the obligation are not limited to trade-related aspects of labor does not mean that the panel has concluded that the EU panel request refers to methods which have no connection to trade. So must be loosely connected, but must not be specifically concerning the bilateral trade. So 3 provisions were Korea was found in breach of the obligation to respect, promote, and realize because its legislation, let's say, is too restrictive, for instance, the definition of worker. Whereas for 1 provision, it found there was no breach. As to the second, that was interesting, the ratification of this convention. Well, the panel said that Korea efforts are less than optimal. There's still much to be done. But the fact that at the last minute, Korea presented the ratification of these to Parliament, the bills for ratifying this convention, the panel finds that Korea has not acted inconsistently with the last sentence, that is, make continued and sustained effort. So you see, since this is maybe not a binding panel to be issued to report, the panel has been a little bit more descriptive and also promotional in this effect. So it says there is no breach, but the efforts by Korea are less than optimal. Korea, until this panel, had been for many, many years, had done really from the signing of the agreement in 2009, entered into force in 2011 provisionally. We are in 2019. Korea had done very little or almost nothing. Now the EU summary, if you go to the website of the EU, you can see that it's in less legal terms. Korea needs to adjust its labor law, and the commitment requires, for ILO convention, requires ongoing and substantial effort. One would expect that at a certain point, Korea does ratify this convention if it has presented the bill to Parliament. And the last one concerned the jurisdiction, that they are legally binding. Okay, I come to my last, because time is going, slide, some reflections and conclusion. So, you know, there is a discussion that FTAs have non-strictly, I call them trade matters regulation. Is there binding? Are they binding? Is it appropriate? Should it just be trade, or on the contrary, should the agreements cover more non-trade issues? And here you have 2 examples. There are difference of context in respect of WTO. So the FTAs are development of the law because they give space to trade and sustainable development much more, for instance, than all the WTO agreements. Interpretation of identical provisions, for instance, Ukraine claimed that, well, Article 35 is not really identical to Article 11 of the GATT, and the interpretation should be less restrictive. This failed. Of course, the bilateral framework doesn't go beyond the parties. But of course, if Korea will ratify under, let's say, the pressure from the EU under the agreement, it will be something useful also in respect of other countries and the whole Korean economy. Now, there are recent EU policy documents on EU and WTO, reform on WTO, more active trade enforcement, the appointment of a trade enforcement officer within the Commission. As you may know, one could consider that these, I have no inside information, these two proceedings show a more effective and more engaged enforcement by the EU of these agreements. The EU has also some other proceedings in course of which I don't know much. There is with South Africa, for instance. There had been with Algeria. And so one could expect more recourse to bilateral. So someone has noted that the EU could have brought the same dispute against Ukraine at the WTO, because basically there was a breach of Article 11 of the WTO. So the choice of bringing it bilateral, is it more effective? Is it short? Of course, now that the appellate body is paralyzed, and so also de facto the panel proceedings don't lead to anything. Are there more instruments of cooperation, bilateral or even of pressure to obtain enforcement rather than through the WTO? These are questions. And then implementation issues, because I don't know anything about the implementation by Ukraine of the report of the panel. And there are too some regulation on this, and the timing should be rather short. And of course also how the means to implement this group of experts or panel of expert report, which is not really binding in the sense that they are an obligation and that can be enforced through sanctions. I think this is the end of my presentation. I thank you everybody for your attention.
Thank you.
I'm ready for questions if there are any.
Thank you very much, Giorgio, for the presentation of these two cases, the Ukraine one and the Korea one. Interesting to listen to you and to see how you perceive the outcome of these two reports. Maybe before starting with more specific questions, how would you assess I would say the procedures, the mechanism in the WTO and the one in this bilateral free trade agreement, except that, of course, the appellate body mechanism in the WTO is blocked for the moment. But how do you perceive, because you were acting in both type of procedure, how do you feel as a panelist in these two different, I would say, formats? Is it almost the same for you as a panelist, or does it make a difference? And if it does make a difference, what kind of difference do you notice?
Well, I think the basic difference is the absence of secretariat and also of an organization. So the panelists here on this bilateral, especially it's the first one, are very much on their own. They have to correspond, to talk with the parties, to organize, to set the dates, the hearings directly, a lot of mails going back and forth. So in this procedure was somehow new ground. Of course, the parties were cooperative under the agreement. If the parties would not be very cooperative, it could be more difficult. And the panelists then don't have the benefit of background papers that the Secretariat would do in Geneva, tell you what are the precedent, what is the case law. If you look at this panel report, it looks like very much a WTO panel. There is a list of the cases of the WTO are cited a lot because it was really the case law, both under Article 11 and Article 20 was the case law of the WTO. So the lack of support is something a little bit novel. Also, you know, someone of the panel said, but there is no one to to book the air tickets for me, someone who was used to go to be a panelist in Geneva. There, the secretariat does everything. So here you have to se débrouiller. But I mean, it worked fine at the end. I mean, and you see the times have been also respected. And I mean, from the starting really of the proceedings in January to the end in early December. So it took less than 11 months, notwithstanding this problem, which is less than what a panel usually take in Geneva. So this can also show in the WTO reform that the panel organization could be better also there. Probably the panelists in a system like this one, the bilateral, even without secretariat, are more engaged. They have to maybe to work more actively in order to perform, whereas maybe in Geneva they rely on the secretariat. There are other cases, the secretariat is busy, the panelists do other things for the governments often, and so it shows that bilateral it can be efficient.
And in terms of substance, in the legal provisions that have been discussed, of course, if I take the Korea one, the Ukraine one, you have, of course, Article 11, 20B and G, as you mentioned, and then the chapter on sustainable development. Of course, if it would have happened before the WTO, as you mentioned before, because you said the European Union could have started a case before the WTO, that would have meant probably for Ukraine not being able to invoke the chapter on sustainable development and the whole discussion about it. What do you think of this?
Yeah, I think you are correct. The agreements, if you look at the context, they have different provisions, and this chapter may be relevant, especially as here you have a forest product. Of course, if you would have maybe an industrial product at issue, it wouldn't make such a difference. And in fact, there has been, if you look at the panel report in the case of Ukraine, there are several reflections on is that chapter relevant to interpret Article 11 under the bilateral agreement, for instance? At the end, the panel said no, because already Article 20B and especially 20B concerns the protection of plant life and health, and so endangered species. And in Article 20G, it was said, well, just a general ban of export of unprocessed timber had no support in the chapter 13. Although there is an article on cooperation on trade in sustainable product, that might mean that the parties could agree on some selection mechanism to ensure that trade the products, the wood exported when the ban will be lifted or so, or transformed, will be somehow grown sustainable, for instance, not coming from illicit trade. For instance, the EU has a regulation on very important to fight the illicit trade in illicitly cut, let's say, wood, trees, and there is a labeling, but there was no evidence about whether this system was applied with the trade with Ukraine. It's rather meant for tropical trees, but could be also applied to others.
Yeah, sure. I can see this is, I think, a very important difference, because for the European Union, all these sustainable development chapters are particularly important because they are considered as part of the common commercial policy now, and they are really, I would say, a tool to promote the achievement of the SDGs, the Sustainable Development Goals. So it's a way for the European Union promoting also multilateralism and sustainable development. And as we know, as we have seen in the position of the US, there is a big reluctance to bring these sustainable development issues within the WTO. So if it is a way of going through it, probably the bilateral way for the European Union is much more important than going through the WTO system, which is of course limited to, if I may say it like this, limited to 20 as justification. Well, yeah, I think these are really very interesting element, as the arbitration panel was mentioning about Chapter 13 can serve as a relevant context for the purposes of assessing. So this is really the position the panel took as far as Chapter 13 on sustainable development is concerned. Well, I know that you are rather limited in your comments, so I should not go. I don't know if you want to make any more comment on these chapters and the relations with the movement of goods under the GATT or not.
Well, yes, I mean, it was underlined that it's relevant context and it has to be taken in account. Although in this case specifically, especially on the 2015 ban, there is a paragraph that says we don't see how this Chapter 13 would be relevant. I mean, if this ban as was found in breach, would not be saved by the existence of a chapter that says one has to promote sustainable development, which is also an obligation domestically a lot. And Ukraine put evidence, the effort they have been recently doing, for instance, to fight illegal logging and corruption, which is connected with illegal logging. But this is not directly connected with justifying a general ban that is not justified under Article 20G.
Yeah. Okay, Giorgio, if you agree, we can take one or two questions that I see in the chat. There is a first one on I would say, the consequences of the panel. It relates to the potential suspension of trade concessions in case of non-compliance to the panel reports in these situations. So it's yeah, consequences and potential suspension. What would you comment, Giorgio?
Well, I have really no comment. I mean, if you read the articles of the agreements on trade chapters and on dispute settling, there is an approach which is similar to the one of the DSU at the WTO, but of course lacking the concept. So there is a concept of a reasonable period of time. If there is a there is no tentative indications, differently than from the DSU. If the parties have a dispute, it would go back to the panel to determine the reasonable period of time. Then the measures taken to comply have to be announced at the other party. If the other party is not satisfied, it could go back to the original panel. And as last resort, there could be proportionate trade suspension. But I think, and one should hope, that in a bilateral framework, it should be easier for the party to ensure compliance to their bilateral cooperation, of course. Whereas in the WTO framework, if you have on one side a country in Europe, on the other side a distant country in Asia or Latin America, maybe there are less means of cooperation to facilitate compliance. So in this respect, it will be interesting to see what happens between EU and Ukraine.
Sure. Okay, we can have a look at other question. Is the system of ad hoc panels going to last for years, or is this a temporary replacement due to the crisis of the WTO system? What would you say?
Well, I mean, the bilateral panel system is enshrined, of course, in the in the agreement, so they are not temporary. Now, whether in this moment of crisis of the dispute settlement in Geneva, there will be more recourse to bilaterals, I don't know. You know, it depends from various, also the subject matter of the dispute, because I don't think that these FTAs cover the whole area of the GATT, of course. And there are certain provisions in which, of course, they refer to GATT obligation, then they could be brought under bilateral agreements like here. The GATT has other obligations which are not referred to, I think, in bilateral agreements. So, and then the other important point is even the EU, which has many FTAs, doesn't have, with, of course, a great number of countries. So if the EU has a dispute with, as it has had with Brazil on chicken cuts and Thailand, so it couldn't be brought to a bilateral agreement because there are no such bilateral agreement, for instance. Or these countries, it was these countries jointly against the EU. So I think maybe the example of this first panel, bilateral panels, if also implementation will be successful, because of course the parties look at the result, not just what is written nicely in the report by the arbitrators, but what will happen in compliance in the real life. If this is successful, maybe this will encourage the EU and maybe the other parties to these agreements to use more these bilateral schemes.
Yeah, of course, this kind of mechanism is provided in the new generation of free trade agreements concluded by the European Union. But yeah, see the UK, European Union agreement, you have dispute settlement. As you are maybe aware, in the discussion about the framework agreement with Switzerland, there is also a kind of a dispute settlement, bilateral dispute settlement mechanism that could be provided if the agreement is agreed upon by the parties. So I mean, it's not exceptional. It's becoming rather a trend in the new policy of the European Union. So, but as you rightly said as well, all agreements do not contain all type of rules, provisions of the WTO, and that for sure, yeah. We do have also a question on, yeah, it's more a policy question. Is this approach developed by the European Union should continue or not? So would you like to give I would say, an assessment of that new development? Is there any other actors, international actors, that takes the same trend? That's for sure. The US is not taking these sustainable development chapters trend, that's for sure. Others, maybe Giorgio, do you have any
Well,
comment?
in this agreement, the CAFTA Dominican Republic, there is this panel mechanism of non-trade matters, let's call them. And maybe in that respect, and also in the NAFTA, maybe in that respect, the EU was more pioneering than the EU, and maybe the EU has followed, I don't know, somehow this example. I have read that, of course, the fact that the US lost the panel with Guatemala by a rather strict interpretation of the provisions, or the interpretation has shown that the provisions of this agreement on labor standard were not enough to be not enforceable really before a panel, gives rise to reflections whether the text should be stricter or it's not a good way. The result of the panel, EU-Korea, seems to be reading it rather positive in the analysis of the fact that these obligations, which are basically engagement to apply the standards of the ILO, because the ILO lacks a mechanism, compulsory or or even non-compulsory to enforce these obligations, except reports, periodic reports by the ILO. And so this summing up of the two mechanisms appear to be interesting.
Mm-hmm. Do you think that the WTO dispute settlement mechanism would be more, I would say, generally speaking, in favor of countries that would not like to invoke the sustainable development type of agreements? Then the bilateral way would be, I would say, much more favored for them than the WTO system, if we look at from this perspective.
You mean if a country wants to enhance the role of the sustainable and environmental chapter, then it would the WTO is less favorable. I mean, the case law of the appellate body has been quite open to defenses based on non-trade. I mean, you look at seals case, turtle and shrimps case, of course, asbestos for the human health. Yeah. So also the WTO affords through Article 20 a good
yeah, but you see, these are
defense. But
these are
maybe the trade and sustainable developments are more promotional. I mean, they engage the parties to do more, to cooperate, to reach. In the UK, there is the agreement with the UK has lots of provision on that. There is an engagement of both parties for green neutrality, energy neutrality in 2050. I mean, these are two parties, of course, at the same level of development that subscribe the same type of environmental and labor standards. So it's easier there to say no reduction, compliance with ILO convention, no reduction of the labor protections. But there too, there are mechanisms to enforce them.
Yeah, but you see, Article 20 of the GATT is the 36 of the TFEU. So it's the same way of dealing with justification to violations of the.
Yeah, you can add more.
Whereas the other one is another perspective, which is different.
Well, I mean, the EU, which wanted to push the vis-a-vis Korea, the labor chapter, let's say, had no other way than go bilateral. There is engagement. There is no such engagement in the WTO.
In the WTO, that's for sure. But this is when it is only on this, yeah.
Well, the same provisions are in the Ukraine agreement now. The Ukraine was an export ban, and of course it was something typically a trade restriction.
Sure. Okay, I think that we have another question, if I looked at it correctly. It's about the effectiveness of the system, but you already touched upon. Would you like to say it more, develop a bit more on effectiveness of these two systems, of WTO and bilateral?
Well, the WTO has shown to be rather effective. I mean, maybe compliance has been slow and maybe slower in recent times. You have seen more 21.5 disputes. So, and this is maybe worrying that there is a lot of dragging the feet, I have the impression, on effective compliance by, let's say, losing parties at the WTO. And so even if sanctions had been resorted, rarely the purpose, of course, is not to go to sanction, but rather to get compliance or agreement on compensation or some solution that respects the rules. In a bilateral framework, it might be easier to obtain compliance. There is also, I think, more engagement to make these bilateral agreements work, because you can measure the benefits in trade terms or other. I mean, this agreement is very important for Ukraine. Of course, it's a progress toward, if not joining the EU, but to approaching the economic and legal standards of the EU. So one could think that the Ukraine would not like to have a quarrel, long-term quarrel with the EU on the export of food between really neighboring countries, you see. So in that aspect, it should be.
Yeah.
I see there is a comment. Unlike for the Guatemala cases, Dr. Heavely, the agreement has no stake. Well, the Guatemala agreement, I don't know it exactly. Well, the case was lost by the US, so I imagine that the US could have method of pressures against Guatemala to have Guatemala comply. And I mean, the increase of level of labor law, of course, it's something that everybody welcomes. It's not just a question of a trade mechanism, and or the same of Korea. Although, of course, low standards make economy more competitive, and these agreements say, because Korea raised, there is a provision that these provisions are not meant to make a country lose its competitive advantage, something like that. So, you know, there is always a balance. Maybe you cannot pretend, or they don't intend to bring the level of, I don't know, labor laws in Guatemala to the level of the United States, but still it is to enforce their own laws. So the laws, the local law be enforced. And we know in many countries, sometimes the laws are not really seriously enforced. And this happens not only in developing countries, but even in members of the EU, including Italy, if I may say.
Okay, thank you. Thank you with these words, Giorgio. I would like to thank you again for this excellent presentation and for the very open discussion we had, even if it was virtually. Unfortunately, I hope to be able to welcome you physically in Geneva soon. And I would like also to thank all the participants. And I know that we had a very important audience today. Thank you for your participation all, and I hope to see you soon again at the University of Geneva at some time. Goodbye.
Well, thank you to you for having organized, and also to all the audience. And I'm happy that there was such a broad interest, and you, Christine, told me. Bye-bye, see you soon.
Goodbye, goodbye, Giorgio, goodbye. Goodbye, everyone. We close.